In 2016, a Craigslist sting operation targeting would-be child rapists led to the arrest of 13 people in Spokane. This included husband and wife Tim and Sandra McManis. At the time of Tim McManis's arrest, Washington State Parole seized various electronic devices as evidence, including cameras, tablets, and hard drives. Mr. McManis entered a plea agreement with the state, pleading guilty to second-degree assault with sexual motivation. At the hearing, the plea was amended to include the return of McManis's property after 1 year. Ultimately, Mr. McManis was sentenced to 27 months for his crime. Despite the agreement, the evidence was sent for disposal. McManis requested the return of his property and submitted a formal motion. Unable to deliver the terms of the agreement and without an order for a specific remedy, the trial court denied this motion. Now, McManis is appealing to a higher court in an attempt to remedy the issue of his missing property. Let's take a look.
This case is about according fundamental fairness to Mr. McManis. According to the plea agreement, he requested the return of his personal property, and instead of responding, 6 days later, the state destroyed it. That was a breach of the agreement. Under significant constitutional principles that undergird plea agreements, a remedy was required. Yet the court erroneously declined to give one, finding that because specific performance was an impossibility, no other remedy was available. That was an error of law, and we are requesting that the court remand for a consideration of the remedy.
I've got a question. Just throwing something out there. You probably have never done divorce law before, but there's such things called property settlement agreements that parties agree to how they're going to split the parties or the property, and it becomes part of the divorce decree. And so it's filed with the court. In those situations, if there's a violation and property isn't returned the way it's supposed to be according to the property settlement agreement, then there's no need to file a separate lawsuit for breach of contract. They go in front of the court that had jurisdiction over the divorce proceedings, and they have that particular judge in that matter make a decision as far as how to fix things. Should this situation before us now, should it operate in that same way?
Yeah, Your Honor, it already does. Frankly, in the United States Supreme Court in Santobello said it needs to. Whenever you have a breach of a plea agreement, the remedy is always delivered in the criminal court where the agreement was reached, entered on the record, and then effectuated. When there is a breach, say, before the sentence is served, if there's some sort of breach right after the plea colloquy hearing, that court is always the one to rectify it. I've never heard of a circumstance where the remedy can't follow in that court where the remedy...
Isn't that what Judge Hazel said? Judge Hazel said that you have to file a separate matter, separate lawsuit?
Indeed.
Okay.
That his only remedy would be through the civil courts. And there's no case law backing that up. And instead, I think the case law coming from the Supreme Court under Santobello is that court, this trial court, had to impose a remedy.
Can there be specific performance if the property no longer exists?
Your Honor, that's a good question. I think in one sense, yes. And thinking about it as terms of, okay, he wants specific performance for his property back, but the property doesn't exist. Well, the next best thing, the value of the property is the next best thing. And to get specific.
But you haven't asked for the value of the property, have you?
Not on appeal, Your Honor, no, but they certainly did below. But the issue on the in front of the court right now is that the trial court just said no remedy was available. That's the legal issue here. So we are just asking for remand for a determination of the remedy.
Assuming we agree that there can be a remedy in the criminal proceeding, should we decide what that remedy is, or should we remand to the trial court to decide what the remedy should be?
In short, Your Honor, the latter. But I think the decision here doesn't need to be anything more than a reiteration of what this division said in 1979 in State v. Johnson, that trial courts can fashion ad hoc remedies. You're not limited to specific performance or withdrawal of a plea agreement. There are other possible remedies. The trial court is best situated to determine what that is.
Should we expressly say one way or the other whether money remedy is available?
Court doesn't need to, but I think that would be most beneficial for the trial court.
Okay, Judge Stahl, you seem to have a question. I saw your hand go up.
No, sorry.
One thing that occurs to me too is that under contract law, the primary way of enforcing the bargain that was made is to fulfill the expectation interest of the parties. Your client expected to have the property without the need to hire his own lawyer. I know there's an issue at least raised below, perhaps even on appeal, whether he's entitled to have a publicly appointed lawyer to assist him in recovering his property or the value. Would part of the remedy possibly include having counsel at public expense appointed to help him? Or if the state objects to that, to have the state pay for his own private attorney to fulfill that expectation interest?
Just a clarifying question, Your Honor. Are you asking about appointed counsel for the civil case?
Yes. Well, look, in this particular criminal matter, if we were to reverse, we haven't conferenced this case, so I don't know what the other judges are thinking. But if we were to reverse and say that in this particular matter, the trial court can fashion the appropriate remedy, should we let the trial court fashion it based upon expectation of interest? And the expectation was that he wasn't going to have to pay for an attorney to have this property returned. Should we be clear that the trial court has an option of either appointing counsel at public expense or having the state pay for his own private counsel?
I'll answer it in two parts, Your Honor, and forgive me if I'm misinterpreting the question, but the first response is he already had an appointed attorney, and the duties of counsel extended to this matter.
Okay.
I think that was clear. And as far as the expectation here, I think Mr. McManus's reasonable objective expectation was that the property would be returned if the state didn't object. The state didn't object, yet the property was destroyed.
Right. Okay. So basically, we don't even have to go that, because clearly, we're still, if we say that he gets to make this argument in this particular case, doesn't have to file a new lawsuit, he already has appointed counsel.
Indeed, he does. And that is the simplest, most efficient, expedient option. I mean, this happened in the trial court. The trial court tendered, I should say that the trial court effectuated the agreement. Sentence was carried out. That court knows everything that happened already in this case. It's most efficient for that court to resolve this dispute.
The particular property involved, it may have had like photographs and things of that nature. Is that correct? Some personal items on it. Was there anything of sentimental value that, in other words, for example, pictures of a relative that no longer is alive, that, in other words, simply the value of a 5-year-old camera might not adequately compensate him? Is there anything of that nature here?
Yes, multiple data drives were taken. All of his personal files were on those drives. He also had 833 CDs and DVDs that I doubt he could try to get again. As to the specific nature of what was on those or what music in particular was on this, I'm not sure. I just know 833
So
CDs
the
and
value
DVDs.
of these things might be more than replacement cost of these particular, in other words, a new camera may not make them whole.
I mean, perhaps, Your Honor, I don't think the court needs to wade as far into those waters. I think we can look at this objectively and just look, okay, that's the fair market value.
As a former trial court judge, it's always nice to have some parameters set by the appellate court. And
Sure.
we didn't need to make the decision for the trial court, but we certainly might want to put out some parameters of what could and could not be done. So that's the nature of the question here. It's
Indeed.
just trying to figure out what those parameters might be.
I think looking at it objectively, you look at just the property and how much the property is worth. I think it might get too complicated if you engaged in anything deeper. And then you look at the subjective interpretation of what was
Well,
on
yeah, and
this.
his question raises an interesting issue that I don't know is relevant, but obviously he's not asking for emotional damages or anything like that, just for the recovery of property. Okay. Not saying, you destroyed the last remaining picture of grandma and me and I'm devastated and I should get $1 million in emotional distress.
No,
Okay.
no, he's not.
Was there child pornography on this equipment?
No. So just as a backdrop, all of this digital media computer equipment was taken as a part of the case. But then when they searched through all of it, the only thing incriminating they found was the messages that he had sent to the detective. So it's evidence that they already had. As far as anything additional, they didn't find anything incriminatory.
Under Washington case law, is Mr. McManus's remedy limited to withdrawing his guilty plea?
No, I think this court has said clearly in State v. Johnson that it's not. In that case, the court looked at the two more conventional remedies, which would be withdrawal and specific performance. And given the very unusual facts in that case, they said neither would be adequate. So this court can fashion, as other courts have done in the past, ad hoc remedies for the violation of the plea agreement.
Why would withdrawing the guilty plea be an inadequate remedy?
I think this court on that point should look to the Supreme Court in State v. Tortolot. I might be mispronouncing that. There, the Supreme Court looked at the possibility of withdrawal and found that it would be fundamentally unfair to focus on that remedy. Most of the sentence was already served. I think the same here. He served not most of the sentence, the entirety of the sentence. The state has already gotten its benefit by not having to go to trial and still getting a conviction. Mr. McManus has he served all of his obligation by pleading guilty and then serving his sentence. It would be fundamentally unfair to put him in the worst position of having to redo or even face possibly a worse outcome just because of this issue.
However, I understand those are the circumstances in this case. In another case down the road, there might be different circumstances. So he should have the option, correct? Is that what you're saying?
Well, perhaps, Your Honor, and defendants do. The election is accorded the greatest weight, yet the trial court still has discretion. Frankly, I think that's why I couldn't find any case law throughout the entire country that matched this fact pattern, because it is so unusual.
Might it be an abuse of discretion if the trial court required him to withdraw his plea?
I would think so. Yeah, I would think so. I think that would be fundamentally
You
unfair.
might find us an agreement if it comes up on appeal.
So let's say in the conventional circumstance, right, the sentence hasn't even been served yet, and they have two options. You can withdraw, or you can get specific performance of, say, the sentence that you had bargained for. It wouldn't make any sense for that defendant to say, hey, actually, I want monetary damages. The trial court, in its discretion, would say, absolutely not. That doesn't make any sense. But in this unusual circumstance, just like the court confronted in Johnson, you have to look at the other possible remedies. When the conventional ones don't work, there still has to be a remedy under State v. Harrison to return the defendant to the status quo. So the whole point here is it was legal error for the trial court to say that there was only one remedy for you. It doesn't make sense, so I'm not doing anything. That's the problem.
You're in your rebuttal time right now.
Oh, and I will reserve. Thank you, Your Honors.
Mr. Pierce, from the questions and comments, you might suspect you have a heavy lift here.
Thank you, Your Honors. Good morning. Brett Pierce on behalf of the state. Would you like to start with questions, or would you like me to speak a little?
I'm just curious as to why you think we shouldn't reverse.
Sure, Your Honor. The trial court in this instance actually found that no breach occurred because the contract term was too ambiguous to be enforceable, was the court's actual ruling. And I know that it's been recast as the court didn't think that other remedies were available now for purposes of argument, but that's not what the ruling was below.
What is ambiguity?
Ambiguous.
Ambiguous, thank you, Chief.
That's why we sit as a panel.
Ambiguous about this agreement.
Sure, Your Honor. So the actual term that was written into this plea agreement on the morning of the plea was property to be returned to defendant or his designee 12 months after sentencing if no objection from the state. So I can detect two ambiguities. The first thing is property to be returned is in the passive voice. And that's critical because this court and Mr. McManus have been equating WSP with the state, but I'm not sure it's quite that simple.
Have been doing what?
Equating the Washington State Patrol with the state of Washington as in the prosecutor's office. And I'm not sure it's quite that simple of an analysis.
Are they both agents of the state of Washington?
They're both agents of the state of Washington, but WSP is a state agency. and they're represented solely by the Attorney General's office. And when they come into possession of property, there's a statutory scheme that requires them to do exactly what they did in this case.
Well, you're representing the state of Washington, aren't you?
We are, well, yes and no, Your Honor. The sovereignty of the state of Washington is in the executive authority, but I don't know that we can bind WSP to engage in activities that are contrary to the statutory scheme.
Then why did the state enter this agreement?
I don't know, Your Honor. From the record, it looks like that wasn't the offer that was forwarded by the assigned deputy prosecutor, but the morning the plea was entered, defense counsel just requested out of nowhere for a coverage counsel to agree to
Did the
this.
state warn Mr. McManis that we may not be able to do this?
Well, that's the other part of the ambiguity in here. The second half of the sentence says, if no objection from the state. So it was actually an illusory term of the contract. Nothing here says the state had to object or not, or what reason it could have given. It says, if no objection from the state. Now, it turns out the state didn't object.
Was there an objection from the state?
There was not from our office and not from WSP's investigators.
I'm
But
sorry.
no, well, Your Honor, that was a fantastic question. No, it is important, I think, Your Honor, because it goes to show how this is an unenforceable term because A, the ambiguity, the third party who's to return the property, and B, if the state doesn't object, that's an illusory promise. I mean, the state doesn't have any obligation to not object. The state couldn't object.
Is there any case law that says the Washington State Patrol does not constitute the state?
I doubt that case law exists, Your Honor. My point would simply be the agreement here would be, I believe the term is ultra virus, when the state agrees to bind itself to something that's forbidden by statute.
Well, if the state had, let's say, called the WSP and said, hey, we've got this agreement, this property is not contraband, it's private property, and part of the plea agreement is to have it returned after 12 months. Would you please make a note in your file to return it and get it back? You can do that, and WSP isn't bound to destroy it, right?
I don't know that we can do that, actually, Your Honor. Chapter 6335 RCW addresses what happens to all property that comes into the possession of the State Patrol.
Follow-up question then. Let's say that you make a promise that you can't enforce, but the defendant doesn't realize that. They think this is the state of Washington. They can enforce this promise. But why shouldn't the state still be liable for the damages if it made a promise it can't enforce?
The state might be liable, but that's part of the problem from this prosecutor's office perspective. Mr. McManis came into court and asked for the prosecutor's office to pay for WSP destroying property when perhaps WSP should be paying for destroying the property.
I thought he asked for the state to pay, not the prosecutor's office.
That's not how our office interpreted his request, which also said he requested specific performance, then came into court and said, well, by specific performance, which is an equitable remedy, I actually mean monetary damages, which is a legal remedy. So
Well, who made the promise? Was it the county or was it the state?
the state by and through the elected prosecutor's deputy attorney.
Then that's
The state.
Whoever made the promise perhaps is the one that needs to be liable if it couldn't keep the promise. Would you agree with that? If it's not illusory.
If it's not illusory, and if it doesn't constitute a formation problem, if this wasn't a mutual mistake, the parties apparently both agreed that the prosecutor's office unilaterally could agree to return property because they didn't realize, even though it was cited below by both parties, Chapter 6335 RCW existed and required the State Patrol to do exactly what it did here. And to that point, Your Honor, I've got another argument that was raised by Ms. Verhoff. I'm not sure a breach actually occurred because property to be returned to defendant or his designee 12 months after sentencing. So Mr. McManus was sentenced on April of 2020 to 27 months in prison. WSP sent notice to McManus via after the state said we have no objection to release, and WSP said neither do we because there's no child porn. The WSP sent the statutorily required notice to Mr. McManus on January 6th of 2021, so approximately 9 months after sentencing. And then it was returned as undeliverable. They held it though. They didn't destroy it right away. They held it, and in March, they designated it for there's 3 procedures under 6335.030 that they can follow. They can auction the property, they can destroy the property, or they can basically appropriate.
What about the fourth one that uses common sense? It says, well, this guy was convicted, he's probably in jail somewhere, let's make a phone call. Is that not an option?
Well, that's probably why Mr. McManis, who wrote this term, said, or his designee.
Right.
So, but I'm not sure if the statute says call them up. It says do these 3 things after you give your statutorily required notice. But here's the critical thing, Your Honor. When that notice was returned undeliverable and they kept it in March, they didn't destroy the property until June, which was 14 months after sentencing. So 12 months after sentencing, WSP said, hey, you or your designee come get this property. He never named a designee, even though he who wrote this term requested the ability to name a designee. I mean, I understand that it feels unfair, Your Honor, but that's the problem with specific performance. It's an equitable remedy, and so you have to abide by all equitable principles, which includes latches. I mean, why did he wait until 2 months after the 12-month period that he wrote in the term to then request the state to become his designee?
So is the issue of breach before us?
Well, not according to the assignments of error, Your Honor.
So did Judge Hazel decide on the issue of breach, or did he just go straight to there's no remedy, so I don't need to decide breach?
Judge Hazel's ruling was this term is not enforceable because it's too ambiguous and or illusory to be enforceable. So implicitly, he found there was no breach at all.
So we have to address breach then.
Well,
Not only whether damages or whether a remedy is available, but whether there was even a breach.
I'm not sure if Your Honor, I mean, absent supplemental briefing, if Mr. McManis didn't challenge the fact that there was breach. This is something that's not even assigned error to. The assigned error is the court said there's no remedy available, which also, frankly, is not true, Your Honors. There is a remedy available. It's withdrawal of the plea, but Mr. McManis doesn't want that remedy, appropriately for the reasons he stated today. But there is a remedy available when specific performance is inadequate, and that is withdrawal of the plea. So when Mr. McManis said, Your Honor and Judge Hazel, I would like specific performance in the form of monetary damages, which isn't specific performance, but I don't want to withdraw my plea, the court said, well, okay, but if plea withdrawal is your only remedy, because specific performance is an impossibility, then you really don't have a remedy under that circumstance.
I get the sense that the county feels that if they did try to settle this case, it'd be a gift of public funds, perhaps. But if, obviously, we disagreed with the interpretation of this agreement, then that would take the county out of the bind.
Well, that could be a concern of, that's none of, we're all moonlighting as civil attorneys right now for purpose of this argument, Your Honor, but the deputy prosecutor below wasn't, defense counsel below wasn't, and counsel today didn't write the briefs, but, we're not civil attorneys in the criminal appellate division as well. So that could be a concern in maybe risk management mind, or if this were assigned to a civil attorney in our office, but I'm not sure that's what was driving the decisions below.
Arguments below, right?
Yeah.
Okay.
Yeah.
What if any other ambiguity was in the language?
The third person of who was to return the property is the big ambiguity, but the no objection from the state is the other ambiguity, although it's more of an illusory term because it doesn't impose any obligation on the state to not object.
Doesn't every contract impose an obligation to act in good faith? So an objection would need to be done in good faith?
Yes, Your Honor. But, and this goes back to the first ambiguity, outside the record, the state just signs a property initials, a property release reform in every case, and that's how property is released. But we don't, WSP may have wanted to keep that while they waited for technology to develop so that they could better search for the child pornography that they thought was on the device. Whether or not we could object had nothing to do with whether WSP's criminal investigators or forensic analysts had an objection because maybe they just couldn't break the encryption. All of that is outside the record.
What wasn't the basis of the bargain, the basis of the plea? Part of the basis of the plea was this agreement that you're now saying is illusory. It seems that he's still entitled to a remedy. Let's say that it was illusory. The fact is, that was the basis of the bargain he's performed. So it seems like even if it's illusory, he's entitled to some sort of remedy.
He is, and according to State versus Barber, Your Honor, that remedy is withdrawal of his plea, which isn't fair to him. It's not. But if the choice is, according to State v. Barber, specific performance or withdrawal, except where specific performance is impossible, Barber's the perfect example, because in Barber, the parties agreed to recommend an illegal sentence, and the Supreme Court said, well, the trial court, the sentencing court, can't impose an illegal sentence. So it's not very satisfying, but your only remedy is withdrawal of the plea.
Thank you. Any further questions? Okay, we'll have rebuttal.
Well, I don't,
Oh,
I still have a couple of minutes, Your Honor.
I'm sorry. I thought you were looking that up. And said you were
Oh,
done.
no,
so
I
sorry.
am
so sorry.
enjoying the questions because this is a fascinating issue, but
Okay.
I just wanted to make sure I didn't hit anything or miss anything else in my
Okay.
notes here. Part of this, I think a couple questions earlier to Mr. Costello were whether this court can just decide if there's another remedy available or whether they should remand it. Normally whether there's a breach is reviewed de novo and whether the contract was integrated is reviewed de novo. But I think in this circumstances, and the state's brief really talks about this, the question here is really about interpretation of the contract, and that interpretation depends on extrinsic evidence, which is all of WSP's, statutory obligations and all of the actions that WSP actually took in this case.
Mr. Pierce, isn't it true that down for the trial court, the state really narrowed the issue? I'm looking at a transcript here and it says, this is by the state prosecutor. However, Your Honor, the issue in this case is the remedy, and seem to hone in on the remedy issue. Not really maybe tangentially raising these other issues, but really saying here the focus is the remedy. And the trial court agreed and said there is no remedy, therefore I can't sign this order. So when you indicate that the judge made these decisions, I don't know that that's necessarily reflected in the record.
Your Honor, that might have been what the state argued at oral argument, but the briefing contained all the arguments, and Judge Hazel's reasoning in his oral ruling, which was incorporated into his written order, was, I can't enforce this because it's too ambiguous, because to be returned without specifying who the actor is, and if the state objects. I believe the trial court actually placed the most emphasis in its ruling on if the state objects, because in Judge Hazel's view, that rendered the entire term illusory. But to get back to the question of whether remand's appropriate, in the state's brief, we cited EAG for the proposition that when a question of interpretation, which is usually reviewed de novo, relies on the assessment of extrinsic evidence, as it does in this case, usually this court will remand for the trial court to make a finding regarding that extrinsic evidence. That's already happened in this case, and Judge Hazel already ruled, or I guess found, the facts of whether this is ambiguous or not.
I have one question. If you were done answering, go ahead.
Oh, no, I'm done.
I know you're done in time, but I wanted to try to move this along.
I am done.
That phrase, if the state objects, you give us some background here that this written promise was made kind of at the very last minute right there. And the attorney for the state making the promise may not have had full authority to make it. One reasonable interpretation, unless the state objects to that language, is that this person wanted to go to the supervisor, make sure that this promise is okay, and their duty to object would have been within a reasonable time after the plea, certainly before the guy finishes his sentence. So isn't that what unless the state objects means? And the fact is that the state didn't quickly object, so therefore that condition's out.
Well, 3 answers to that, Your Honor. First, the state tried to fulfill this term because we did not object. It's
Right.
WSP who followed statutory procedures. 2, the deputy who covered this plea hearing actually was the unit supervisor. But 3, the reason I say that she didn't have authority to enter this plea is not because she wasn't authorized by our office, but because no party, state agency party can contract in a way that flouts statutory law. And that's where the ultra-virus lack of authority stems from in this case. The prosecutor can't say, we're going to relieve WSP of its obligations under Chapter 6335. And they didn't. I mean,
What in the statute was violated by this agreement?
Mr. McManus requested the property returned 12 months after sentencing. WSP was required to give statutory notice, and they did, but I believe they did it early. And that was part of the problem below too, is that Mr. McManus raised on behalf, or Mr. McManus alleged that the state breached the agreement by signing the property release reform in December, which was 8 months after the sentencing hearing, when in fact we do, the state just signs them because they come across our desk, but WSP stored the property and continued to store it.
I'm still not sure what under the statute was violated by this agreement.
The term of the agreement says property to be returned to the defendant, but WSP can't just return property to a defendant just because. It has to follow that notice procedure. It has to, it's not a permanent bailee for Mr. McManus either. So that's why when they give the notice and the notice isn't returned, or Mr. McManus or his designee who he bargained for doesn't show up, WSP is not obligated to hold it in perpetuity, and that's why the statute allows them to destroy it. So Mr. McManus is really reading into this term, state, you can make WSP give me the property back 12 months after sentencing, and also if I don't bother to come pick it up until 15 months after sentencing, WSP is just kind of storing it for me this entire time. So that's why I say, Your Honor, that it is outside the statutory parameters, because the statute doesn't say WSP hold this until somebody comes 50 years later. It says if notice is given and it's not responded to, you can destroy it, or you can keep it, or you can sell it.
Any further questions?
Yeah.
Thank you.
Thank you, Your Honors.
Mr. Cataldo?
Thank
Would it be unfair if the state made a promise that it couldn't enforce, where your client reasonably believed that the state could enforce the promise, and then your client, serves his term in jail? Would it be fair for a court to say he's not entitled to a remedy?
No, it wouldn't. Just as basic principle of fundamental fairness, no, it would not. The one thing I want to focus on, though, is the statutory framework that the state is bringing up at argument today. And I think there's a good contrast between, say, an illegal sentence, which can't happen under a plea agreement, and something like this, where there's a framework that exists, but nothing in this agreement says, okay, that framework needs to be violated. Yes, there might need to be a good faith effort to comply with the agreement and the statutory framework, but they're not incompatible. So I just wanted to be clear there. Yes, there is a statutory framework, but nothing that is contemplated in this agreement would violate it per se. The other aspect that I want to respond to would be the 2 points of apparent ambiguity in the agreement. Property to be returned as it relates to WSP as a third party. The court asked the state about what authority guides the interpretation on that issue, and there are two. First, it's the plurality decision from Sullivan, which frankly I didn't brief. But then, which I did brief, is State v. McDonald from the Supreme Court. And I think it is actually pretty simple that WSP would be an arm of the state here. And that is particularly because the prosecutor directed WSP to destroy the property. I think that's dispositive on that issue.
What about the state's argument that there were alternating reasons for Judge Hazel's decision, one being that the contract was basically not enforceable?
Yes, that's on page 18 of the transcript. And I think it's important to track the court's pretty brief ruling. And I think your question to the state was on point, where not only did the state make its entire argument really about the remedy, but the court did too. And it started that paragraph saying, with respect to the remedy. And then it goes into saying, well, we can't do withdraw. The only other remedy would be a financial remedy, but the only way I could do that is with a sanction. And then it addressed the court rule for sanctions, and then it said, well, I'm not finding this is intentional because there was no certainty, the plea agreement, that he would get the property back. So, I mean, the state's correct that the court was talking about the objection provision, but it's not as if the court was so clearly saying, okay, this agreement was ambiguous. The court made that finding in passing when it was discussing whether it would impose sanctions. And I think that is an important distinction. After that paragraph, it goes on to continue discussing remedies, the apparent lack thereof. I think the whole focus here was on this implicit understanding that there was a breach. I mean, everyone agreed that the property had been destroyed. The facts were not in dispute. After that, the court does proceed to discuss remedy. So I think it's fair to say that the majority of this, if not the entirety, was on the remedy issue.
Thank you.
Thank you.
Um,
You're over your time, unless
I am.
there's something you think is just so important that we haven't covered yet.
There's not.
Very
Thank you,
good.
Your Honors. We're asking the court to remand for determination of remedy. Thank you.
Thank you both.
Following these arguments, the court remanded the case back to the Superior Court to enforce the property agreement and permitted the court to exercise its discretion when determining the appropriate remedy. What do you think about cases such as this? Electronic evidence seized in child abuse related cases? What is appropriate compensation for Mr. McManis? Let me know what you think in the comments below. And if you like this video, please hit subscribe. Until next time, folks.